Good evening, everybody. This is ILW tonight. Just see who from Undice is online. Good evening, Claudine. I see you with us tonight.
Good evening, Advocate Kleinans. Yes, I am.
How are you?
I'm just going to post the link in for the recordings for you, for your students, and the evaluation form. Because before I could even tell them add your student number, they were already
I
busy
saw they
doing
were
that.
adding, yes, so they're used to it. Tell me,
Yeah.
Claudine, do you have any other announcements for us before I start?
Now you can start. So I'm just going to paste the link there for them for the recording so it's easier for them because the Dow sent that to me. And all the recordings will be found there in the evaluation form. And then, of course, the one-on-one sessions, they must, if they want to book the one-on-one session with you, they must also do that. When are they writing?
I think this one is the 2nd of December. I must check.
Oh, okay. By the time you have a whole month to prep them, so they'll all be getting distinctions then.
Yes, I hope so.
Shame, no pressure. It's different ball game writing. Okay. I've just pasted. I'll do my admin. You can go on. Okay.
Thanks, Claudine. Students. You must paste your, not paste, you must enter your student number into the chat, and then Miss Claudine Peterson from UNISA is going to put the link for past recordings down for you, and then they will also put the link for the evaluation session down. Can any student quickly, just for information, yes, Claudine, the exam is 1 December. Eh?
I'm listening. I'm here.
The exam for ILW is 1 December. I'm putting it in the chat. No?
Okay.
Okay, thank you.
On my birthday. It's also
Oh,
International AIDS Day that day, no?
yes. So
they must wear their red pins when they're writing.
yes.
Okay.
Okay, that is on a Tuesday. So I'm not going to go to work that Tuesday. I'm going to come visit you. Thanks,
The link
Claudine.
for the recordings is there. Okay.
Got it. Thank you so much. Okay, students, good evening. Are there any questions for me on last week's discussion? There's one or two aspects I want to touch on in terms of last week's discussion before we go over to study unit 12, which deals with the different types of legal disputes and courts in our country. So, before I start, any questions for me? Any questions? Okay. If there's no questions, then I see Michelle Forbes is here. Michelle, do I owe you a consultation session?
Good evening, Advocate.
Hi
Yes,
there.
I've completed all the admin and filled in the forms, but I'm not sure if
When
it's needed though. But
when did you fill in the forms?
maybe about 2 weeks ago.
Okay, so fill it in again, resubmit it, and I will give you a time slot tomorrow morning. No?
All right, I'll resubmit it
Okay.
again. Okay.
Any other questions from your side?
From my side, or
Mm,
everyone?
your side.
Oh,
While
my
I have
side.
you on now.
Oh,
Any
yes, I
questions
do.
from you?
I was actually just with regards to the appearance in court. I was just speaking to someone today who needs to appear for maintenance, to maintenance court in the magistrates court, and he said that he's going to be representing himself. And so I was just wondering, why do attorneys have to go through or need permission to appear in court when lay people have the right to represent themselves without any legal training or anything?
Okay.
I was just wondering about that.
I'm going to explain that to you as in the most simple terms possible. Okay, so you can switch off your mic and then listen to me. Yeah? Okay, students and Michelle Forbes, in the South African legal system, okay, when you are a party to a legal dispute, okay, and here I'm referring to any type of legal dispute because we're going over to the types of legal disputes in our next learning unit now. So when you are party to any legal dispute, may it be a criminal charge or a criminal dispute or a civil dispute, in South African law, you do have the right to represent yourself. Legal representation is not a must. Okay? Legal representation is not a necessity, it's not a must. It's your choice to give an attorney instructions to appear on your behalf. Remember, legal representatives can only operate in terms of a mandate, so they must get instructions from a client. Ms. Forbes, the best way I normally explain this to lay people is making the example of going to the dentist. Okay? I will say, so if you want to go to the dentist and you're complaining to the dentist that your two back tooth are rotten, okay, and the dentist tells you, okay, it's 300 Rand per tooth to extract your teeth, and you say, no, dentist, it's too expensive. I'm going to do it myself. And what do? You go to the person who's the car mechanic who works on your car and you tell him, take the pliers and extract my two back teeth. Okay? That is an example of someone taking on a legal matter without representation. What is that person going to do to his mouth? He's going to cause more harm to his mouth. He's going to cause more infection to his mouth than just paying the dentist who's trained as a professional to do the job. The same with legal representation. Okay, so taking on a legal dispute without the necessary legal knowledge and without the necessary legal training is like going to a war without a gun. Okay, Michelle, that's the best way I can explain it to you. Does it make
Okay.
sense?
Yes,
Does it make sense?
it makes sense.
Okay, so Michelle,
Thanks.
as part of the South African legal system, you are able to represent yourself. Okay, if
Okay.
you are a direct party to the legal dispute. So let me make a further example. You now saying this friend of yours must go to maintenance court. Okay, because it's your friend, you can't now, because you're a law student and you know a bit of the law, you can't now go represent your friend because it's your friend. Okay, so as a legal professional, you must have standing in court. Okay.
So the best I could do is just make sure that they get the help that they need,
Yes.
but not from me
Okay.
to advise them to rather get professional help in order
To
to
get
be
a lawyer to
successful.
go represent them.
Yeah.
Okay.
Okay.
To go get a lawyer to go represent them.
Yeah. So even
Okay.
though they do have the right to represent themselves, which will complicate the process or delay the process, it would be advisable to get legal representation
It would
for
be
things to go
advisable,
smoothly.
yes.
Okay.
Yes.
Got that. Thank
Okay.
you.
Got it. Any other questions from other students before I continue? Any other questions from other students before I continue? Did you see the chat function? Okay, no questions. So if there's no questions, I just want us to quickly just go to page 215. Okay, and let's look at the functions of a legal practitioner in practice. Okay, so the best way I'm going to explain this to you students is that an attorney is a legal practitioner of law. Okay, and I'm going to make the following example. And I need you to guide me on the answers here now. Okay, you can use the chat function. There's someone who is irritating me because you're not switching off your mic. Okay, I don't know what your name is. I can't pronounce it, but you come online and your mic is continuously on and you're irritating me. I'm removing you from the group. Okay, so I was saying I'm going to make this example to you now. Okay, so let's say you fall ill. You wake up and you wake up with stomach cramps. Okay, and now you need to go and consult with a legal professional. Okay, students, who are you going to consult with firstly? Who are you going to consult with firstly? Or you have severe headaches that don't want to go away? Who are you going to consult with firstly? Just put the answer in the chat function for me. You are going to consult a doctor. But what type of doctor are you going to consult? Thank you, Angela. You are going to consult your GP, your general practitioner. Okay? So we normally refer to this doctor, our doctor of first choice. Okay? When we feel ill, we refer to this as our GP or our house doctor. Okay? And then let's say the lawyer says you have some kind of growth in your head or some kind of growth in your stomach, whatever. Which doctor must you go to now? Which doctor must you go to now? Anyone? What does one refer that doctor to? Very good Michelle, very good Asipe, very good Alistair. Angela also. We refer to this as a specialist. Okay, so a specialist physician or specialist doctor is this doctor that specializes in a certain discipline in terms of health. Maybe if you have a heart problem, you'll be referred to a cardiologist. If you have an eye problem, you'll be referred to an ophthalmologist. Okay, if you have to have an operation, you'll be referred to a surgeon, okay, a specialist doctor. Now, this is the best way I can explain what an attorney is. So, when you have a general dispute of law, okay, an employment dispute or a contractual dispute, or you need a will drafted, or you need legal advice, the first person you are going to contact is the general practitioner of law, and that is the attorney. Okay, so that's the person we are going to speak about first. Okay, so attorneys are trained lawyers. Trained lawyers, you have an LLB, you did your articles of clerkship, and you wrote your board exams, and you were admitted as an attorney. Okay, so hence you are a trained lawyer who can advise and, very, very importantly, represent clients in court. Okay, so the functions of an attorney is to provide legal advice in divorce matters. This is all general legal work, the drafting of wills, drafting of legal documents such as antenuptial contracts and purchase contracts. An antenuptial contract will be drafted by a notary. Okay, transferring of property from one person to another, that's a conveyancer. Administration of estates, and also very, very importantly, legal advice with regards to claim as a result of accidents. Okay, so this is some of the work an attorney does. Okay, we've spoken last week about the fidelity fund certificates and who must and why attorneys must have a fidelity fund certificate. And on page 216, the last paragraph on the top, it tells you the purpose of the fidelity fund is to reimburse or compensate clients who may have suffered financial loss due to misappropriation by the legal practitioner. Okay. Now, the following is also very important, students: appearance in courts. Who may appear in court? Okay. So, in the past, attorneys only had the right of appearance in magistrates' court, in lower courts. So we say, in the past, okay, attorneys had automatic right of appearance in lower courts only. Okay, meaning they did not have right of appearance in high courts or any other superior courts. Okay, then in 1995, there was the enactment of the right of appearance in courts, Act 62 of 1995, where attorneys, very, very importantly, students, where attorneys could apply to the registrar that's me, of the Provincial Division of the High Court to be granted the right of appearance in High Court. Okay? So, attorneys who acquired the right of appearance in High Court could also appear in all superior courts, meaning the SCA as well as the Constitutional Court. But you must be mindful that the Right of Appearance in Courts Act has been repealed and it's been replaced by the Legal Practice Act. Okay, so Section 25, students, of the Legal Practice Act now regulates the right of appearance of attorneys in court, meaning that in terms of the Legal Practice Act, okay, attorneys still do not have automatic right of appearance in High Court, and they must still apply for right of appearance. So it means attorneys who wants to appear in the High Court, the SCA or the Constitutional Court must again apply to the registrar of the division of the High Court in which court he was admitted and enrolled as an attorney for the prescribed certificate in order to obtain right of appearance. Okay, so once you admitted as an attorney, students, you must have at least 3 years. Okay, listen to me very carefully. You must go read Section 25 of the Legal Practice Act. You must have at least 3 years post-admission experience before you can apply for your right of appearance in a superior court. Okay? Any questions for me? Any questions for me? Any questions for me? No questions? I want us to go to page 218. We're going to look at the functions of an advocate quickly. Okay? We have to look at the functions of an advocate.
Sorry, advocate. How are you today?
Is that Angela?
That's me. How are you, sir?
Very good. Very good. How are you?
I'm good, thank you. Just a quick question. Why are there two different exams for the attainee and the advocate? What is the difference? I see here the attainee can only write the attainee's admission examination, and the advocate must write the bar exam. What is the difference between the two?
Remember the example I made to you of the doctor and the general practitioner and the specialist.
Mm-hmm.
Okay, so the general practitioner and the specialist also write different exams. Why? Because although they're in the same discipline, although they're doctors,
They specialize in different things.
They specialize in different things.
Okay.
So the same with an advocate. Okay, an advocate's bar exam is going to concentrate more on the drafting of heads of argument. Okay, where the attorney's board exam won't stress so much on factors like that. Why?
Okay.
Because advocates are specialists of law, especially in terms of litigation and the drafting of pleadings and heads of arguments, etc., etc. Okay, because remember, in high court litigation, okay, everything is done in terms of the papers you submit to court. So an advocate must be, aside from the field of specialty he or she is in, they must be a specialist in terms of drafting and writing. Okay? So because of the different degree of work they do, their training is different. Their vocational training is fundamentally different. Okay? I hope
Yeah.
that makes sense to you.
It does. Okay. So you're saying their vocational training would be more intense, right?
For an advocate,
For advocate, yes.
yes, yes,
Okay.
yes.
So, but then why is an advocate only doing 12 months of vocational training and an attaining 24 months?
Because they specialize in certain aspects of the law. Okay?
Okay.
So an advocate does not need to know how to do bookkeeping. So an advocate will not do the bookkeeping exams because they don't deal with clients' money directly.
Okay.
Okay, so
Okay.
that's
So there'll
just
be
an
extra
example.
modules for the attainee because they specialize in most of the stuff of law.
Yes. So
Okay.
an attorney must know how to draft wills and stuff like that. An advocate doesn't need to know that because they're not going to work with wills and estate to that degree where they consult with a client. But an advocate will be briefed by an attorney to do an application to set a will aside in the High Court on the basis that it's an invalid will or something like that.
Okay.
You
Okay.
see what I'm saying?
Yes. Thank you so
Okay,
much.
so it's fundamentally different.
Okay. Thank you, sir.
Okay, any other questions from other students? Any questions from other students? No questions? Okay, so I want us to look at paragraph 11.5.2. Okay, and it tells us, like attorneys, advocates work for their own account. And I told you, advocates are specialist litigators and spend most of their time representing clients in court. Traditionally, okay, I'm speaking traditionally, when the profession of attorneys and advocates was a split profession. Okay, when it was a split profession, traditionally clients have never approached advocates directly. Okay, clients rather approached attorneys who did the initial work or investigation on the case. And then only, if necessary, the attorney may have referred the matter to an advocate. What you should be mindful of is that advocates, in 95% of their work, only do high court work or superior court work. Okay, high court, SCA, as well as constitutional court work. Okay, that is the playing ground for advocates. Attorneys, mostly 90%, 100% of their work is in lower courts, magistrates court. Okay, so the advocate will then take the case further, write opinions, and appear in court. Okay, so in the past, only attorneys accepted instructions directly from members of the public. Advocates were not allowed to do so. I said there was a separation, it was a split profession, meaning the separation between attorneys and advocates professions indicated that attorneys and advocates played specific roles in servicing their clients' interests. Okay, so what has happened now, which you must be mindful of, is that the Legal Practice Act has changed this traditional position. The position I'm talking about is the split profession. Okay, so meaning the Legal Practice Act has changed this traditional position that distinguishes between two kinds of advocates. Okay, so it's advocates and fidelity fund advocates. This means that clients may now approach fidelity fund advocates who are in possession of their own fidelity fund certificates directly without an attorney. Okay, advocates can provide legal services for a fee now. Meaning, if an advocate like an attorney now applies to the Legal Practice Council for a fidelity fund certificate, this advocate may now engage with clients directly. Okay, therefore, clients will no longer have to approach an attorney. Okay, so the Legal Practice Act also regulates the position of advocates by way of a fidelity fund and a required fidelity fund certificate. Okay. Then page 219, if we look at paragraph 11.5.3 and we look at the rights of appearance of advocates, okay, it tells us advocates have always had automatic right of appearance in all courts. This includes lower courts as well as higher courts. Okay, and Section 25 of the Legal Practice Act has not changed this position. Okay, so also in terms of the Legal Practice Act, advocates have automatic rights of appearance in any court in South Africa, students. Okay? Any questions? Okay.
Yes, advocate, one last question.
Mm.
So after going through all the training to become an attainee, can I switch over to becoming an advocate, and would I have to go through the same process again?
Okay, you can switch over to become an advocate, but then you must do pupillage for a year and you must do the bar exam. Okay, so
Okay.
then when you go do your admission is twofold. Firstly, to remove yourself from the role of attorneys, and then to enroll yourself on the role of advocates.
So you can have
Okay,
both roles.
you can't have both roles. You
Okay.
must have one role at a time. So you must either be an attorney or an advocate. That is the choice you can make. Okay.
Okay.
So I had friends. Let me give you an example.
Mhm.
I had friends that did the articles. Okay.
Mhm.
And a few years later, they decided no, they don't want to be attorneys anymore. They want to do advocate. They want to be an advocate. They applied to the bar. They did their pupillage. They did their bar exams. They were successful, meaning they now removed their name from the role of attorneys and they were admitted as advocates. Okay.
Mhm.
But then 5 years later again, they decide, okay, no, I don't want to be an advocate anymore. It's too lonely in the chambers. I want to be an attorney. Okay, meaning now they bring application again to have themselves removed from the role of advocates and have them be put back onto the role of attorneys.
But they don't have
Okay,
to write the attendance examination anymore.
they don't, if you write the attorney's exam once and you were successful, you don't have to rewrite it again. The same
Okay.
with the advocate's exam. Okay, but in my case, okay, in my case, I never went to go do articles. Okay, so
Okay.
I don't have the choice of saying, Owen Kleinans, you don't want to be an advocate anymore. You can go remove yourself from the role of advocates and enroll yourself on the role of attorneys. I
So you
can't
would
do
have
that
to start from the beginning.
because, yes, then I would have to start from the beginning, go do articles, and yes, write the attorney's admission exam. And that is something I will never want to do because for me, at the stage of my career that I'm in and where I find myself, it's like giving up my Mercedes Benz and wanting to drive a Toyota.
Okay.
Okay. And that is something I will never do.
Levels,
Okay.
advocate
So,
levels.
yes. So, there's also for us as counsel, okay, we refer to ourselves as counsel, for us as advocates, there's also a status attached to being counsel, okay?
Mm.
Because if you appear in high court, okay, and there are attorneys in court as well, okay, the front benches in court must be reserved for counsel, and
Only. No
attorneys
attorneys
must,
can sit
yes,
there.
and attorneys must sit at the back, or if there's no place, they have to stand, okay? But counsel gets preference.
Okay.
Okay.
So the bar exam would be the highest in law.
Yes, yes,
Okay.
the highest in law. Okay, you
Thank you,
got that?
advocate. Yes.
Pleasure. Any other questions? There's no other questions. So if there's no other questions, let me just see if I'm finished with this unit. Um, okay, let's just go to page 223, paragraph 11.7, and that is presiding officers. Okay, so the first type of presiding officer we're going to look at are judges. Okay, so judges are presiding officers in higher courts. That is our constitutional court, our SCA, our Supreme Court of Appeal, as well as our High Court. Okay, meaning a judge is required to have an excellent knowledge of the theory and practice of law. Okay, most of you don't know this, students. Judges are appointed for life. Okay, so it means a judge never retires. Okay, and when that judge becomes of the age where the judge no longer wants to be a judge or no longer wants to come to work and he decides to technically retire, that judge receives his or her salary and all related benefits for life. So a judge doesn't go on pension, a judge gets his or her salary for life, meaning they're appointed for life and they may come from any of the branches of the legal profession. So traditionally, judges were always appointed from the bar. Okay, and very, very importantly, because the judge is public office. Okay, the president of the country as head of executive of government appoints judges after consultation with the Judicial Services Commission. Okay, and the Judicial Services Commission consists of members of the legal profession and is independent of both the legislative and the executive branches of government. Okay? Then, lastly, I'm going to conclude with the following. I'm going to conclude with the following. Magistrates. Magistrates perform a similar function to judges. However, they preside over lower courts. That is, district and regional courts. Okay, magistrates are also required to have a solid knowledge of the theory and practice of law, and magistrates are appointed by the Magistrates Commission. Okay, and that concludes this section. Okay, you of course have to go through all the other court officers and familiarize yourself with that. Let me just see if there are any questions. Okay. No questions, it's just admin. So now I want us to go to page 231, and we're going to look at the different legal disputes and courts. Okay, we're going to look at different legal disputes and courts. So all of you, go to page 231 for me, please. Okay. Okay. And many of what appears in Learning Unit 12, I have spoken about. Okay, so students, on page 233, let's look at the different kinds of legal disputes. So there's mainly three kinds. Okay, we have civil disputes, criminal disputes, as well as constitutional disputes. Okay, and to constitutional, I want us to add administrative law disputes. So technically, we have 4 types of disputes, which may be civil, criminal, constitutional, or administrative law disputes. Okay. Now, by means of introduction, it tells you the following. Okay, I'm by paragraph. I'm under 12.3. I'm in the beginning of 12.3.1, where it tells you that in Learning Unit 1, you learn that the state prescribes certain norms or rules of conduct that bind all members of society. Okay, and that these rules are legal rules for the law. Okay, now in the next paragraph, it tells you a civil case or a civil matter is a private law dispute between ordinary people or individuals, meaning these are legal subjects. Okay, disputes between different legal subjects, and the state is not necessarily involved. It's incorrect where it says the state is not involved, because the state can be regarded as a legal subject in terms of a private law dispute? Who can give me an example? Who can give me an example where the state is a party to a civil dispute? Anyone? Can you give me an example? You either tell me or you put it in the chat function. Joel, magistrates, Alistair, can you explain a civil case against the state? Joel, magistrates are not appointed for life, not as yet. Okay, so they don't have that same benefit. Magistrates retire at 60 or 65. Okay, they must go on pension. Okay, they're not appointed for life yet. Alistair, can you give me an example of a civil claim? Come on, people, this should be easy.
Advocate, can I give you an example?
Yes, is it Michelle Forbes? Okay.
Yes. Would it be where someone is entitled to free medical care, maybe from a state hospital, and when they approach the hospital, they are denied access to healthcare? Would that
And
be
then
an
what
example?
happens? And
And
then what
they,
happens?
well, depending on the nature of the case, they could then take the state to court and claim damages, or not damages, but
Which
try to get
branch
an
of
order.
state? Which branch of state will they take to court? Which branch of government?
They would take the executive.
No, the executive is the president. Which part of the executive? Okay,
Oh,
they will take the Minister of Health.
the Minister of Health.
So, yes. So, example, Minister of Health. Another example, let's say on Saturday night, I have too many whiskies, okay? And I am caught in a roadblock. They arrest me. And what happens now? Police beat me up in the police cell, in the detention center. Okay, what do I now have? They assaulted me. I have a claim for damages against the police. Who do I sue? I sue the police minister. Okay, so that's an example. We had two examples now: Minister of Health, Minister of Police, where where the state can be regarded as a legal subject in a civil dispute. Okay. Any other questions? Any other questions? Let's continue. Okay, let's continue. So, parties to a civil matter have to decide whether they want to initiate proceedings. Okay. One party will take the initiative. That is mainly the plaintiff or the applicant in our civil matters. And I told you the purpose of a civil matter, I stated to you before, in terms of a civil matter, the purpose of a civil matter is to grant a remedy or relief to a person. Okay? A person can, for instance, institute a claim for performance, such as the payment of damages. Okay? A civil matter takes place between two parties. This is an action proceeding between the plaintiff and defendant, or an application proceeding, okay, between the applicant and the respondent. You must be mindful, I've spoken about this already, that in terms of an application proceeding, an application can be brought to court by one party. And when it's brought to court by one party, we refer to it as an ex parte application. Okay, an example of an ex parte application is you in this group in about 6 or 7 years from now, you would have either done your articles or you would have done your pupillage, and you will now bring application to the High Court in your own name, an ex parte application to either be admitted as an attorney or as an advocate. Okay? As an attorney or as an advocate. Okay? Very, very important. Here comes terminology, people. Terminology. So, the outcome of a civil matter is that the action or application is either allowed or dismissed. Okay? Civil cases may be heard in lower courts, district and regional courts. Civil cases, depending on jurisdiction. Okay? District court, the civil jurisdiction of a district court is up to 100,000 rand. Okay? Regional civil jurisdiction is up to 400,000 rand. Okay? So district civil courts may hear civil claims up to 100,000, and regional magistrates courts may hear civil claims up to 400,000. Okay? So civil cases may be heard in lower courts as well as the high courts, SCA as well as the Constitutional Court. Okay? The High Court can be a court of first instance. So any quantum may be heard in the High Court, but the High Court civil jurisdiction starts at 400,000 Rand and up. 400,000 Rand and up. Okay? The SCA only hears appeal matters. It's the highest decision-making court in civil and criminal appeals. And then our Constitutional Court is our highest decision-making court in constitutional matters. Okay? Any questions? Any questions? No questions? Okay. So very, very importantly, I'm going to paragraph 12.4, and these are modules you're going to do in your third and second year. When we deal with civil disputes, the law of civil procedure regulates the process or proceedings that legal practitioners must use to bring private law disputes before the courts. Okay? So there are two types of civil proceedings that legal practitioners can institute, namely an action proceeding or an application proceeding. Okay? These proceedings are complicated. Okay? That answers the question of, I think, Michelle, who asked me earlier, why can people on their own represent themselves? So here it's starting to make sense to you, Angela, or I think it's Michelle. Very, very important about this paragraph. Michelle Forbes, these proceedings are complicated and legal representatives must assist the parties to take the required steps, firstly, to collect evidence and bring the case before court. Okay? So, although civil procedure in high courts and magistrates' courts are more or less the same, differences do exist. Okay, since action and application proceedings are complicated, okay, we're only speaking about it briefly because you are going to do all of these in the law of civil procedure. Okay, so briefly, in action proceedings, proceedings by way of summons, there are fundamental differences between the parties with regard to the facts of the case. Okay. So when it comes to an action proceeding, there are two opposing parties involved in the action, the plaintiff versus the defendant. I told you previously, the plaintiff is the party who initiates, starts this action, because that is the person alleging damages, loss, or harm. Okay? The cause for instituting the action can be a delict if the party has suffered damages to property or has been physically injured. It can be in terms of contract, there is a breach of the contract. Okay? Or it can be a divorce. Okay? The defendant is the party against whom the action is instituted and who may raise a defense against the action instituted by the plaintiff. Okay? In the name of a civil case instituted by way of an action proceeding, the plaintiff's name is cited first, followed by the letter V, which represents versus or against. Okay? And versus speaks to the system, the court system we use, and that is our accusatorial system. Where someone is accused of something, accusatorial system. Okay? So, in an action proceeding, the plaintiff starts the action proceeding with summons and particulars of claim. Okay? These are written documents in which the plaintiff informs the defendant of the claim against him or her. The particulars of the plaintiff's claim follow on the summons and contain the following information. Very, very importantly, the names of the parties involved, the facts of the case, what happened, the extent of the claim, what the plaintiff's claim is, the remedy or relief that the plaintiff asks from the court. The plaintiff usually also demands the defendant to pay the cost of the lawsuit. Okay? So the plaintiff will usually ask for a cost order as well. Okay? So before the trial starts, there is a pre-trial stage during which parties exchange further documents. These are notices and affidavits to disclose to one another what evidence they plan to use during the trial. A pre-trial conference may be held where applicable and a trial date set. Okay? An affidavit, very importantly, is a written statement given under oath before an official who has the authority to certify the statement, for example, a commission of oaths. Okay. Any questions so far? I see no questions. Okay, if there's no questions, I'm going to continue. Okay. And on the top of page 236, I told you, in a civil case, the party who alleges bears the onus of proof, meaning the burden or duty of proving. This is normally the plaintiff. Plaintiff is regarded as dominus litis. So the plaintiff must, very importantly, satisfy the onus of proof on a balance of probabilities. Okay? This means that the plaintiff must be able to prove that it is more likely that what he says is true. Okay? The onus of proof in a civil case is not as heavy as in a criminal case. Okay? The trial in an action proceeding ends with the court evaluating all the arguments and evidence and then handing down a judgment or a finding. Okay? If the party against whom the judgment is obtained, okay, does not voluntarily comply with the court order, execution of the court order or ruling follows. Okay, execution is a method by which the court's order is enforced. Okay, and that is normally with the assistance of the sheriff of the court. Okay, if parties are not satisfied with the court's decision, this party can lodge an appeal, apply for leave to appeal. If any of the parties are not satisfied with the process followed during the trial, they can apply for review of the trial. Okay, review of the trial. So, let's look at motion proceedings. I told you there are two types of application proceedings. Applications are with notice of motion. It's either ex parte notice or motion applications. Okay? Application proceedings are used when there are no fundamental differences between the parties regarding the facts of the case. Okay? The only real issue to be decided are on issues of law. Okay? There are two parties involved, namely the applicant and the respondent, because the legal relief required by the applicant affects the rights of the respondent. Okay? In the name of the case instituted by way of motion proceedings, the applicant is cited first, okay, and the respondent is cited next, okay. Application proceedings are instituted by way of notice of motion. In the notice of motion, the applicant applies for a form of relief or a court order, okay. The notice of motion is served on the respondent, and an affidavit must accompany the notice of motion. Okay. Very, very importantly, for example, of a case where a notice of motion proceedings is appropriate, where someone applies for an interdict compelling his or her neighbor to stop the noisy wielding business that he runs from home during the week. Okay. Another example can be of a case where an application is appropriate where a landlord cuts the tenant's electricity and the tenant brings an application to court to have the electricity restored. In such a case, there is no dispute that the landlord has cut the electricity supply. The main issue is whether the landlord was entitled in law to do so. Okay, so it's an issue relating to the law and not to fact. Okay, I explained to you what an ex parte application is. Okay, a notice of motion is a similar document to a summons. In application on motion, it contains the details of the applicant and the respondent and the relief that the applicant is asking for. Okay. At the end of application proceedings, the court will either grant or dismiss the application. It is also possible to apply for leave to appeal or review of application proceedings. Okay. So students, I've spoken a lot. I've read a lot to you. So what I'm going to do is I'm going to stop here tonight. I'm not going to give you any homework. Okay, you must just familiarize yourself with the civil disputes and that there are. And next week, when we continue, we will speak of criminal disputes. Okay, are there any questions for me? Are there any questions for me?
Hi, Advocate.
Yes, Angela.
Yes.
Okay.
It's not related to what you've just explained now or discussed, but something I'm very curious about. I want to understand, what does it mean when somebody says they are pleading the fifth? I just need to understand how that works.
Okay. Remember, this you mustn't confuse our legal system with the American legal system.
So we don't
Okay,
have
because
such in our legal system.
no, I'm going to
Okay.
explain it to you. The fifth is similar to our law where you remain silent. Okay. The reason for remaining silent is to protect yourself against self-incrimination. Okay. So
Okay.
in terms of criminal law, when it comes to a person or an arrested person, okay, in terms of your rights, we refer to it as your Miranda rights, okay? You have the right to remain silent, okay? So
Okay.
if you are arrested and you don't have a legal representative appointed for you yet, or you haven't been given the opportunity to contact a legal representative, and the police officer wants to ask you questions, they want to interrogate you, you have the right to say, I want to remain silent until I consult with my legal representative.
Okay,
So,
so the right to remain silent is equivalent to pleading the fifth.
yes, yes.
Okay.
Okay, you
Because
got
I
that?
checked again, I couldn't find it anywhere in our law. Hence, I was asking if we do
So
have such.
next week, when we speak about aspects of criminal law, and when you also do the various modules related to criminal law, you will see how
I don't think I
important.
have them because I'm doing a BCom law.
Okay, but eventually, when you switch over to LLP, you
Oh,
will do
okay.
criminal law. Yeah?
Okay.
Okay.
Right. Thank you,
Any
sir.
other questions? Okay. Students, any other questions? Um, Angela, Adele Angela has spoken to me. I'm arranging she submitted a written work, and I'm going to arrange a consultation session with her. So that has been agreed. Okay. Students, so there's some admin for you to do. You have the evaluation form to fill in. You have to put your student numbers in, and you can download the previous recordings. So I am going to stop here tonight, and then next week we deal with the aspect of criminal trials. Okay. So students, thank you so much. We speak next week. Have a good week ahead. Good evening.